This is the Sentinel Editorial Board. I'm Steve Bosquet, the opinion editor. You just heard from my colleague, Deputy Opinion Editor Dan Sweeney, and Martin Dykman is also with us. Martin is a veteran of decades of Florida journalism experience, much of it in legal affairs and the court system, and we're all going to ask questions. And this is not a debate in the literal sense, but it's a free-flowing conversation, and feel free to, raise your hand or politely interrupt if you feel a point needs to be amplified or you need to respond to something that your opponent said, and so forth.
Okay.
So, I want to begin with you, Kaysia Earley, and ask you a question that's an obvious one, but it's one that I want you to realize is important to us at the Sun Sentinel. A person, I know this is an issue of great debate for decades in Broward legal circles, and I've been covering the court system there since the 1980s. And so some people, take exception to the fact that a lawyer would challenge a sitting judge. We don't feel that way, but I would say this. I would say that I'm speaking for my colleagues, that a challenger has the burden of making a compelling case why the incumbent should be turned out of office. And so you face that responsibility in this case. And so I do want to begin by asking you to summarize. We've read your questionnaire, but why would you make a better judge than Ms. Levey Cohen?
Well, I believe that there are certain qualities that a judge should possess and also exhibit while on the bench. And for years, I've always been knowledgeable of the court system as a former assistant public defender, as well as a private criminal defense attorney. And I have the opportunity after trying over 100 trials to verdict, I've been able to go in front of many judges to see what a judge should be on the bench and what a judge should not be on the bench. And there are concerns about this sitting judge, which is why I decided to run against my opponent. Specifically, I think it's very important that a judge has the proper judicial temperament. I can't stress that enough. When you are in a position of power, especially in a courtroom, you have people, whether it's civil, whether it's criminal, that they're already there with a level of stress, a level of uncertainty. So you as a sitting judge that possess so much power, you have the responsibility to be respectful. And obviously, I have those concerns of the opponent. I do possess that judicial temperament necessary, not only to my fellow colleagues, but also to defendants. We know that they're presumed innocent until proven guilty, but most importantly to officers of the court. You can disagree as an officer, you can disagree with the officer of the court, but it's important not to deny an attorney, whether a prosecutor or a defense attorney, access to the record. Because when you cut them off, it prevents them from laying the proper record for an appeal.
What?
And there has been, go ahead.
I'm sorry, yes, sorry to cut in there, but tell us briefly, what specifically has Judge Cohen done on the bench that raises questions about her temperament?
Well, it's been reported actually by the Sun Sentinel, I believe in 2017. It's been reported on NBC. It's her behavior, her bad behavior on the bench. She's been labeled as a bully on the bench. And I dare to say that she's been labeled as a bully off the bench. Her behavior has exhibited some concern, most importantly, to not only colleagues, but also us in the legal profession who have to go before Judge Cohen. And that is of great concern, because if you are afraid that the judge will rule against you because he or she is having a bad day, but specifically dealing with Cohen, my opponent, that is of great concern. And within the legal community, it's well known that her behavior has caused concern to the point where the former public defender, who used to be my boss, has not only challenged to get her off of the bench because of her bad behavior, but also has fully endorsed me as a former employee because he knows that under pressure, I do not lack the professionalism, and I have that ability to be respectful. So okay. That's of great concern for me.
Okay. Judge, you've just heard your opponents laying out this bill of particulars. Tell us what the record shows from your perspective.
Okay. I have been a judge for 12 years. I have a spotless record. I have never had any charges against me for bad temperament. I have always been respectful. I have integrity. I serve with a strong knowledge of the law, as well as living life for 61 years. I know life's challenges. I wrote this in my paper and my questionnaire. I am mindful of people when they come to my court and they're upset, they're overwhelmed, they're anxious. So when they're in my courtroom, a lot of them are small claims cases. I have to be especially patient with them. I have always done that. There's never been a problem. I can tell you the situation that Miss Earley's speaking about. What happened in that situation was one time in 2017, and again, 12 years I've been on the bench, and there's never ever been an issue about this. It is probably not well known, maybe it is well known, but Howard Finkelstein, he doesn't like judges. He's no longer a public defender, but he always made that very clear. He knew me, I knew him for years. Our children grew up together. And he always told me, you know, the judges give me a hard time, so I'm going to give them a hard time. So his young public defender appeared in front of me. She was having a bad day, not happy with my rulings. Now, be reminded that everything that happens in court is recorded. Had Howard taken the time to listen to the court appearance that day, he would have known that she was disrespectful and that I had done nothing but try to calm her down and maybe get another lawyer to come in and cover for her. Bottom line is, he wrote a letter to the Sun, not to the Sun Sentinel, and the Sun Sentinel never printed this because it wasn't a real issue. He wrote a letter to the chief judge. The chief judge reviewed it with me and said, I get these letters almost daily about other judges. Listened to the tape. There was nothing on there. And we just moved on from there. The bottom line is that the lawyer that appeared in front of me got a bar complaint for the way she behaved in court. That was the end of it.
Okay. Well, I mean, we've seen that letter from Howard Finkelstein, in which he says you called an assistant public defender in open court. You called her a twit.
Sir, if that was true, I'd have a JQC against me. It was not on tape. It didn't happen. There were plenty of lawyers in the courtroom who can tell you it didn't happen. My clerk was there. I can give you the recording and let you listen to it. There was no, I never said that, and I never would. But, you know, it's easy. You know, it was a toxic situation with the public defender's office. They were constantly in a battle. So that's what came out about it, but none of those things happened.
Let me, I'll get to you just a minute, Ms. Earley. Obviously, we all know this. We have a different public defender in Broward now. Is there still a battle going on between your division and the public defender's office?
I know I have been serving on the civil division for 5 years. And in my service on the civil division, there has not been one time that anyone has ever complained to the chief judge, the administrative judge, or anyone else about my behavior. So okay. This was a stressful time for this public defender. She argued with me. Again, she got the bar complaint. Nothing happened. I was cleared. Nothing happened. It didn't go anywhere. And so, yeah, that's the answer. I've been serving for 12 years with a spotless record other than what they say happened, and there's no proof whatsoever.
Okay, Ms. Earley, you wanted to say something else. Go ahead.
Yes. So in my previous experience as an assistant public defender, at the time, Howard Finkelstein was my supervisor. Obviously, he was the public defender. And I just want to correct a quote because he did not have a problem with all judges. In fact, we would have weekly meetings on Thursday at 12 noon. And a part of the discussion was which judges are on time for court, even as a criminal defense attorney. He applauded that because he said that if it's at 8:30 on the docket, there were judges that, you know, he respected. And obviously there was differences of opinion, but I just want to correct the record that he was not out there bashing judges. He was making note of which judges were actually doing their job and which judges were being mean to not only the defendants, but to his employees, which were the assistant public defenders.
Okay. Ms. Earley, have you ever appeared before Judge Cohen in court?
No, I have not.
Okay. Do you do any legal work in county court?
Oh, yes. I am a private attorney. Like I said, I was a former assistant public defender. So yes, most of my legal work is in Broward. I have some in Miami-Dade, some in Palm Beach, and some in Orlando.
Okay. Now let's shift gears here a second, Ms. Earley. You have an interesting background, and we've looked at your website very closely. I'll summarize this for those who may be watching. As a college student in Washington, D.C., you were accused of embezzlement.
Yes.
Your questionnaire said that your case was put into a diversionary program. And
Yes.
what I'm not clear on is, did you plead guilty to anything? And was there a sentence?
Absolutely. Let me explain. I've been a full book for the past 18 years. I've never
Sure.
hid away from this. In fact, yes, you're right. When I was in college 18 years ago, I had 3 jobs. Don't ask me how I did it. 2 part-time jobs, 1 full-time job, and I was in school full-time. One of my jobs, I was working at a shoe store. So whenever someone wanted to come in, any of my friends, when they found out, I would give them my employee discount. That was the basis of the embezzlement charge. Just to be clear, wasn't taking any money out of the register. I'm not making any excuses. I accept full responsibility, which is why I did accept a plea. So in that state, not in Washington, D.C., but where it occurred, it's called a suspended imposition of sentence. Down here, they call it a diversion program. I did spend time in jail, and that was part of the program. And after the completion of community service, which I did on Capitol Hill, by the way, 200 hours of community service, as well as 3 years probation, which I successfully completed, it was ultimately dismissed. I did not expunge it off my record because I realized when I started sharing that story, especially after I became an attorney, everyone was inspired by it. So I did a lot of community service sharing my story, and I was named Broward County Mentor of the Year. So yes, I completely informed my law school. I completely informed the bar. I am eligible even with my background. And, you know, I've been practicing law ever since.
Okay. Just a couple of small details about, and I appreciate your walking through that.
Yes.
And you fulfilled your community service obligations by working as an intern on Capitol Hill.
Yes, I did.
For who?
Yes, I did.
Who'd you work for?
I worked for the former Congressman Albert when he was in the 4th DCA, the 4th Congressional District, and he ended up being my mentor after this whole situation. So yes, I interned for him. He actually wrote me a recommendation. Yes.
4th Congressional District of where?
Maryland.
Maryland. Okay.
Yes.
Do you have, as a result of all of these circumstances, do you have a permanent criminal record?
It's the arrest is on my record, absolutely. So yes.
Okay. Judge Cohen, in your questionnaire, you said the following, and I'm going to read, Ms. Earley, from what Judge Cohen wrote in her questionnaire.
Please.
My opponent has been arrested, pled guilty, and served time in jail and on probation for a crime of moral turpitude. So I'll certainly give Ms. Earley a chance to comment on that statement, but I want to ask Ms. Cohen, voters can judge for themselves about what Ms. Earley has done, but 18 years ago. But in your opinion, because of what happened 18 years ago, is she unfit to serve on the bench in Broward County, in your opinion?
Okay. The position of judge is one of public trust. Okay. So that means that when the public appears in front of a judge, they need to be secure to know that the person making a decision about their life or their livelihood or any of those other very important things, their property, whatever, has the highest character. Ms. Earley, I think that let me go back. I think that the public would be concerned with whether or not she can be trustworthy and honest because of this crime that she has committed. Now, I can go on further, and I don't really want to talk about her. I'd rather talk about my qualifications. But there are other instances where Miss Earley has shown that there are some issues with her trustworthiness. And one she just mentioned, where she said she worked on Capitol Hill. She tells people that she was a legislative aide on Capitol Hill from 1999 till, I don't know, sometime 6 years later. She was not a legislative aide. A legislative aide is somebody who's gotten a Bachelor of Science, a bachelor's degree, and who has who works for the federal government full time and gives information about the pros and cons of legislation. So there are bits and pieces of this, whether or not there is public trust. Do the people want to go in front of her and know that she's been a lawyer for 7 years? She's actually been a paralegal for the patent office for 6 years, but doesn't tell anyone that as well. So there's a lot of questions about whether she can be trusted. I know that I can be trusted. I'm not bragging. It's not a bragging thing, but I do follow the law, and that's something we all do.
Okay.
And Miss Earley in the past did what she did, but should she be a judge today? That's the question.
Okay. Dan Sweeney, go ahead, sir.
Yeah, Judge Cohen, you mentioned that the lawyer in the case with you was the one who got a bar complaint filed against him. Do you know who filed that complaint?
I do know who filed the complaint. Well, I'm not 100% sure. Let's say that.
Okay,
I'm not 100% sure.
It's public record, so I'll look it up. But and that was relating to the issue in your court?
I mean, let me get this straight. I definitely was involved in. I don't think I was the only one who filed it, but they contacted me, and I did give them information. Absolutely.
So you filed the complaint?
I did not.
Okay. All right. And on your questionnaire, under the questions, have you ever been arrested or adjudicated to a misdemeanor felony? Have you ever declared bankruptcy or anything like that? Have you ever had a JQC complaint? You left all those blanks. So I just wanted to make sure, are those blanks a no?
There's no to all of them. Yeah.
Okay. Just
thankfully.
Double checking. Okay. That's it for now. Thank you.
I mean, you understand that I was told by many people to consider filing that complaint. So I was involved in it, but I believe it's confidential. I'm not really sure. I guess you have to look into that. But I was involved. Absolutely.
Okay. Thank you.
Go ahead, Martin.
Judge Cohen, I'll ask a question that's come up in connection with somebody else who's not involved in this race. Complaints could be made to the Judicial Qualifications Commission that a judge would not know about if the complaint was dismissed on the faces of it as not stating a violation of the Code of Judicial Conduct. I meant to ask this question of somebody else, but I will ask it of you. Would you authorize the JQC to release in other words, would you waive confidentiality for any complaints that might have been filed with the JQC, which they found to be unwarranted?
Okay. The answer to that is no, because I don't want you to do that. But I will tell you that someone did file a complaint against me on this particular case, and that I was cleared. There was no investigation. There was just an initial, because I know that was the question, no investigation, just an initial, I forget the words they use. And they, once they listened to the tape and what I didn't say those words, I was cleared. So it never got to the level of a charge. It never got to the level of a hearing on it. That was it. And again, I've served for 12 years. I've handled thousands is, and hundreds of motions. This is not even a blemish. I mean, I'm sad that it happened and she was upset and had an issue with the court. But all in all, I am very respectful of all the litigants that appear in front of me. I'm very patient with them, and there's never been an issue.
Judge, we are well aware of the natural and institutional tensions that exist between the public defender's office and between the judicial branch, and we're aware of Howard Finkelstein in particular being a very high-profile individual and highly opinionated. But he was elected 4 times as public defender by the people of Broward County. The people of Broward County have a demonstrated respect for Howard Finkelstein, and he put in writing his assertion that he questioned your fitness to serve on the bench. That's pretty serious stuff.
If you read what he said, he questioned that I should be removed from the criminal bench. I don't believe he said the bench. I haven't read the letter in 5 years, so I could be wrong, but I feel like that's what had happened. He thought I was going through something emotional in my life, and he wanted me removed from the criminal bench. He never said I should be removed from the bench, of my understanding.
All right. I don't have the letter in front of me right this second, but
Okay.
you know, and Miss Earley, in your questionnaire, generally, not referring specifically to Judge Cohen in this context, but I wrote this down. You talked about, quote, cruel or callous people in the court system. I mean,
Yes.
who or what were you referring to?
Well, I don't have which section are you referencing, but specifically, again, I have represented thousands of clients, and I just want to correct a few things, if I may. I know you said this is conversational because,
Sure.
unfortunately, my opponent has been resulted into Google searches as opposed to knowing who I am. So some of the things that she's stated is a total misstatement of my experience. I've been practicing law for 8 years, not 7. And within those 8 years, I have the experience of someone who could have been practicing for 10 to 15 years, because within those 8 years, I have tried over 100 trials to verdict. I have represented thousands of clients because I'm in court literally almost every day. I mean, I love trial. I love court. I'm addicted to it. I just love litigating and trying cases. So the years that she had, and even as a legislative aide to this day, I did intern for the congressman, even when I was in high school. And he's my mentor today. I have his cell phone number. So we use different terminology. I did say that I was a legislative aide / congressional intern. That's the proper terminology. So I just want to be careful that her research on Google or however she's Googling me, it's a misstatement. So just be careful about that. And then she made another statement about my criminal history. It was incorrect as far as, can you read her exact quote? Because that could be a malicious statement if that was inaccurate. She said something about arrest. And can you read those again, please?
I will. I'm pulling it up now, but while I
Thank
get
you.
it, I promise you we'll come back to it. But
Okay.
go ahead, Dan Sweeney. Go ahead, Dan.
Ms. Earley, you said that Judge Cohen had said that you practiced for 7 years, and you said it's been 8. You were admitted to the Florida Bar on September 30th, 2014. Is that right? That's according to the Florida Bar.
Yes. So well.
Okay,
if
so
you
it's been
count
like 7.5
September.
years. Can we disagree? It's been
Well,
like
yeah.
7.
Yes, just give me the time. Yes, because if you're going to say how long I've been practicing, at least say the entire time is what I'm saying. It's like you're a sitting judge. But there are some concerns, and I'll tell you why, just to be completely candid with you. I'm a generally just very professional, and I entered this race against an incumbent after doing my research. There were several open seats. I could have, went against anyone else. But after doing my extensive research on all of the open seats, I chose Judge Cohen because of what I saw and the great concern. And I understand that she's been on the bench for 12 years, but obviously the past 6 years she went unopposed. But that's the purpose for re-election. Let the people choose. Let the people see that. And everyone always has a first, right? Yes, this is my first time running for judge, but I'm certainly qualified in the areas of practice, especially with my trial experience, especially with my knowledge of the rules of not only ethics, but the rules of evidence. I have extensive motion drafting experience because that's how I get most of my dismissals. It's through motion to suppress and motion to suppress the statements or evidence. So litigation, hands down. And then also, in addition to criminal, I've also had experience in other areas of law. So when I talk about rude and callous people, I think I also attached something, and that's on transcript, where she's talking to a defendant and calling him stupid. I mean, how do you even say that's a blemish on your 12 years? Just because you have the years. The question is, do you have the respect for the people? This is an extension of community service, and you can't explain that away.
Can I say something?
Yes, go ahead.
Okay. Everybody has a different personality. I'm not extremely aggressive. I'm not particularly charismatic. But I did earn my seat and win a race, and I've served for 12 years. I feel like this interview is going in the direction of being attacked or having to defend myself. I think that the focus should be on, we've discussed that. Now let's talk about the 12 years that I have served. I know that you read my paper, my questionnaire. I was asked to serve on the 4th District Court of Appeals, where I authored 4 published opinions. I have a strong legal knowledge. I've worked at the Attorney General's office, argued at the Florida Supreme Court. I wrote a writ of certiorari brief on behalf of the Attorney General's office to the United States Supreme Court. I have tried, I was a state attorney for 5 years. I was responsible for all those cases in front of me. I worked as a private attorney. I handled cases with people who were scared. I walked them through it. I helped explain to them what the process would be like. And I'm doing that now every day in small claims court, in, landlord-tenant law, in, insurance defense cases. These are complicated issues that I've spent the 10 years learning about, that I bring to the bench. There's a consistency with me. With me, you know that you're going to get someone who knows criminal, who knows civil, who's been a lawyer for 35 years, who's represented people, victims, and defendants. And that's what I bring to the bench: integrity, honesty, legal experience, and judicial experience.
Okay, thank you for saying that. And I understand your concerns. First of all, I went back and I found Finkelstein's letter. You are correct, Judge. He questioned your fitness to serve on the criminal bench, not as a judge. So I stand corrected on that point.
Thank you.
Thank you. And Ms. Earley asked that we precisely read to her the words you used in your questionnaire, Judge Cohen. We think, I know you feel too much time is being spent on these matters, but
Okay.
Fitness, character, judicial temperament, they matter. So,
Okay.
yep. Ms. Earley, I have in my hand that page of the questionnaire, and I'm going to read exactly what Judge Cohen wrote. The community should, however, the question we asked is, why are you a better candidate than your opponent? And in the context of that answer, Judge Cohen wrote the following, quote, the community should, however, know whether my opponent is fit to sit on the bench. My opponent has been arrested, pled guilty, and served time in jail and on probation for a crime of dishonesty and moral turpitude. She committed the offense of embezzlement while working for DSW as an adult in her 20s. That information is essential for the voters to consider when weighing her fitness to sit as a judge, unquote.
That is a misstatement. I never pled guilty. So, and the reason why Judge Cohen does not know this is because my paperwork was sealed because I was in college at the time. So I even had a hard time getting it when I needed it to apply for law school. She's retrieved it. I never, let me back up. It was a suspended imposition of sentence. And After the plea of guilty, the case was dismissed. So let me clarify. The case was dismissed. Oh, what happened?
I think, just briefly lost the connection, but she's coming back. Go ahead. I mean, you can continue.
My concern is everything that I put out there is because I put it out there. Again, I never hid. But the way Judge Cohen is informing the voters, she's making it seem, she doesn't tell them when, and she's making it seem as if it just happened. She doesn't tell them the outcome. So I'm concerned that she's being misleading to the voters. So even with the guilty plea, at least if you're going to tell the story, just be honest with the voters, because I've been honest about my story. So that's my concern. She's misleading them. She's putting fear in the voters so that she could remain on the bench.
Okay, and I'll get to you in just a second there, Martin, but before this moment is lost, Ms. Earley, because I've looked at your website, and on your website, I think it's fair to say, I mean, not only do you not shy away from this episode in your past, you actually present it as almost an asset that makes you a better candidate for the courts. And so I don't know that everyone will agree with that, but some certainly will. But how? Tell us, this is the moment for you to tell us this. How does being charged with a felony and going through the criminal justice system, a exceedingly traumatic experience for anybody of any age, make you better qualified to be a judge?
Well, that's not the only asset. That's one of, and I'll explain to you why. As a teenager working at the shoe store, I of course, you know it's wrong. You're not supposed to give away your employee discount, but I didn't think it was criminal. So I learned from my mistake, and now I'm utilizing it to teach others that, number one, don't make the same mistakes as I did. But number two, no matter what happens in life, you have to work hard and redeem yourself. And to me, that's why I labeled it as a story of redemption, because that was the worst moment of my life, because I didn't expect that to happen. But when I realized that I was going through the criminal justice system, I took full responsibility, which is why I entered into the plea, because I didn't want to fight something as opposed to taking responsibility. But that's actually what propelled me to become a criminal defense attorney. But not only a criminal defense attorney, I started off at the public defender's office because I wanted to represent those who did not or could not afford. Now, you may say, okay, well, just because you went to jail, does that make you better? Absolutely not. But it gives me the unique position from both sides of the criminal justice system. So when someone comes in my courtroom and says, I did what I did because I didn't have any money, or I did what I did because I didn't know it was wrong, I don't want to hear excuses, because I've been there. I've done that. So will I be soft on crime, hard on crime? I'm going to examine each case on a case-by-case basis. But coupled with my past incarceration, look how far, or look how much I've accomplished. Look at my legal experience. Just like I said, I went from the past incarceration 18 years ago to no criminal record, nothing after my young adult years. My criminal history coupled with my legal experience and my judicial temperament and my personality makes me a better candidate. Okay.
Martin Dyckman, go ahead, sir.
To be absolutely clear on this, was your incarceration pre-trial or post any proceeding?
It was pre-trial. That was part of my sentence. So once I accepted the plea, that was part of the agreement. And then if I successfully completed the incarceration and probation, then it was dismissed. They do things differently up north.
How much time did you spend in jail?
Total 30 days.
Just the Montgomery County jail system?
No, it's no, it's not in Montgomery County.
Okay. Remember what county it was?
Not the county, but the state was in Virginia.
Oh, I'm sorry.
DC, Maryland, Virginia is just all together. So I lived in DC, worked in Virginia. But what I can do, Steve, I can actually email you a copy of the disposition so you can see everything, and you don't have to hear it out of my mouth.
I think we would like to see that very much. Thank you.
Yes. Send me a reminder. I'll give it to you.
Judge Cohen, let's shift gears for a second. You spent 4.5 years in the state attorney's office. You worked for Mike Satz, right? What kinds of your microphone has been muted because when you went offline, we lost your sound. So that's right. Just turn it back on. just unmute yourself if you can find it there.
Got it.
There, you got it. What
Thank
kinds of cases did you handle as an assistant state attorney, and how did that experience inform your career as a judge?
Okay. Well, I worked 4 years as an assistant state attorney, but 4.5. But I also worked as a defense attorney for many, many years. So it was a good balance to learn to represent on both sides. I started out in county court. I handled the DUIs and moved up to felony court. Eventually, I was made an a lead felony attorney. We handled all first-degree felonies. There were economic crimes over 100,000. I had manslaughter cases, criminal. I had carjacking, a lot of cases, and then of course I had the first-degree felonies and the second-degree felonies. And eventually they made me a supervisor for county court. So I supervised the young lawyers, learning and mentoring and being a prosecutor. And at that point, I ended up opening my own law firm at that time after I left the state. And then 5 years later, I ran for judge. So.
During the time you worked in the state attorney's office, which court, which division were you assigned to for most of that time, or was there one?
You mean which judge, or?
Yeah, which judge is what I mean. Yes.
I think I was in front of Judge Mark Gold the longest.
Okay.
But they didn't keep you. Nowadays, they keep you a lot longer in front of a judge, maybe up to a year. But back then, they like to rotate you and give you different examples of
Sure.
judges.
Dan, I think Dan Sweeney has his hand up, but I got one more quick question, Dan, before I get to you while it's on my mind.
Okay.
Judge Cohen, you're one of only 2 judges in the 17th Judicial Circuit, sitting judges, who is being opposed in this election. And so my question is one of, do you feel in any way that it's unfair, that it's that you're being singled out somehow when most other judges don't have an election to worry about? They're automatically given another term, yet you have to defend your record, campaign for re-election. What do you think about having to do that?
Okay. I have to say that I think it is definitely fair to run against a judge. It's the nature of the job. Every 6 years, you may get an opponent. In the past, there have been a lot more people running against sitting judges. Normally, the sitting judges prevail because they're good judges. I have to admit to you, Mr. Biscay, that I watched an old interview of yours from 2020 where you asked a similar question. And I guess the point that you were trying to make was that some judges who would add consistency to the bench, who do a good job, they show up, they're punctual, which is what I do. I do my work every day. I come to court. I resolve cases timely, which is really important. And then I get an opponent because of, let's say, one blemish, one thing that happened. Now, it was a bad day for her when this happened, probably not a great day for me, but I've handled thousands of cases and this has not been an issue. So would I rather be doing something else this summer? Absolutely. But I understand why people run against judges, and it's totally fair. And, I will just do the best that I can to prevail in this election and hopefully go back to serving the people of Broward County as I have, and keeping a consistency.
All right. Dan, go ahead.
Yeah, Judge Cohen, on your earlier while we were talking, and also on your questionnaire, you listed your 4 appellate opinions that you wrote as among your kind of high points of your career. I wanted to ask you, in City of Delray Beach versus DeSisto, you approved of the lower court's ruling, but reversed on the remittiture issue, meaning that the pain and suffering was greater than you thought it should be. It was $500,000, and you said it should be more garden variety. Do you think was that an unusual case to you, or do you think pain and suffering damages in lower courts are often inflated?
Okay, that particular case, if you read it, I sat on that with Judge Warner, who had written a case out of Hollywood a couple of years before that. And so that's really what we were going on. It wasn't my decision alone. The three of us made that decision. So what had happened is that there's a law, a statute. This was very complicated, where you can't go over 500,000, I believe the number was. And whether or not we wanted to give him more wasn't an issue. It was, we were capped. That's my memory of that case. I happened to have looked at it the other day when I looked them all up. The issue of pain and suffering doesn't come up in county court. So in front of me, that issue wouldn't come up. But it was a very interesting case, an interesting experience. I had to delve into a lot of law that I wasn't familiar with. And basically, we just followed with the statute. Judges, the job of a judge is to apply the law to the facts, whether we like it or not, whether there's private interests or public interests coming at us. We just have to go on the law and the facts and what is the right thing to do at that point. So the right thing was to follow the statute, and that's what we did.
Judge Cohen, have you ever had to recuse yourself from a case, and why?
Oh, had to recuse myself?
Yeah.
I have recused myself. But
I'm just asking for an example,
I'm thinking I don't recuse myself very often. So I can't, sometimes the lawyers will ask you. I have to tell you, in civil, I don't think I've been asked to recuse myself in 5 years. I think recently there was a case where it was an insurance case, and it was a strange storm that had occurred in 2020 and during the pandemic in May. And I said, oh yeah, I remember that storm because it hit my house really hard. And then after that, the defense said, will you recuse yourself because you were affected by the storm? And I said, absolutely. And it went on to another judge.
Okay.
Yeah.
Understand. Okay. We're coming up against our time limit, and you've both been very responsive to our questions. Really appreciate it. I think we have a few minutes left. I do want to give both of you sort of a chance to make a closing statement, address any issues that you feel need to be amplified and addressed again. Let's do it in alphabetical order. So Judge Cohen, you go first, please. Thanks.
Okay. I think I tried to do it before, but I think that the reason that I should get reelected is because I bring a consistency to the bench. I have a strong knowledge of the law. I've served for 12 years, and I intend to continue I'd love to continue doing that. I love my job. I love my colleagues, working with them in the civil county bench. I've handled thousands of cases. I know the rules of evidence, the rules of procedure, and various different areas of the law. Again, the chief judge and the Florida Supreme Court approved me to sit on the 4th DCA for that one term from September to December 2015. So even among my colleagues, I feel that I am respected for the work that I do. One thing we didn't mention is that I have a 99% rate of resolving cases within 18 months, which is what the legislature wants. They want over 90% of your cases need to be resolved in 18 months. Right now, I have a 99.2% rate of doing that. So I'm proud of my case management. I help other judges get to that point. And I love to mentor the new judges that come in as well. I do have a strong ethics. I think judges need to have a strong ethics because, the public needs to trust them. So in saying all that, I don't want to get into this. I don't want to attack. That's not even the word. Here's what I'm going to say. Ms. Earley has, during this election, committed several campaign violations. She does have several organizations that are looking into her, the Florida Elections Commission, the Florida Bar, and possibly even the state attorney's office. And because of her campaign violations, I don't know if the people of Broward County can trust her following the laws of the state of Florida. And believe me, I don't want to say these things, but by violating the campaign laws, it could give Miss Earley an edge up. But eventually, the things that she's been doing will come back and find, she'll have to answer to them.
Okay. Thank you. Ms. Earley, you have the floor.
Absolutely. And I'll do that first by addressing these allegations. When I first entered this race, I never met my opponent on a personal basis. And all I wanted to do was run a race that I knew that I was qualified for. Since that time, I have been personally attacked by my opponent in ways that I found surprising. And I'll say this because I have to respond to what she said. Those allegations of campaign finance misconduct, that's just one of her tactics to instill fear into the voters, because I've answered with affidavits, and it's an ongoing investigation because of what my opponent has done. I'm confident that not only will I be cleared, but this is a fear tactic, and again, a bully tactic that she has consistently done on the bench and off the bench. In fact, you all can research this, and I will email you, Steve. My address is exempt by statute based on my employment. And in her complaint, she has listed my confidential address as opposed to listing the P.O. box that was on my campaign documents. This is very concerning for a sitting judge to publicly make my address known on a complaint. Judge Cohen knows the rules. She's a sitting judge. So this shows you the type of person she is. But let me tell you who I am. I am a person who is a community servant. And my jail experience has taught me so much about not only giving back, but redemption. And that's why I say that everything that I've done as a litigator was from my past experience on the other side of the criminal justice system. And for years, even to this day, I have worked hard to instill the trust, not only of my children, my 4 children, and my husband of 18 years, but also of the public, which is why I give back so much. As a private attorney, I have given hundreds of thousands of dollars that I've waived in pro bono service because I want to give back. I've been utilizing my story as a mentor to young women and young men to give back. It's going to be a complete sacrifice for me to close my law firm down and to run, to become judge of Broward County financially, and also my freedom. But I know that the amount of experience that I have is second to none. In the 7.5 years that I've been practicing, to represent thousands of clients, that's a lot, because as an assistant public defender, when I started, my caseload was over 220. When I was moved to the separate division, I was moved because I lowered my caseload from 220 to 80. In fact, I held the record before Judge Rabolo, Judge Carlos Rabolo in the juvenile division. To this day, every time I walk into his courtroom, he says, "Ms. Earley, you still have that record of trying 56 trials in 8 months," because I was in trial multiple times, almost every single week. My experience extends beyond the criminal courtroom. I've been a practicing attorney in the civil, domestic violence, restraining orders. So not only do I have the experience in my legal experience, I have the patience. I have the judicial temperament and integrity. Will I be judged what I did 18 years ago, or what I've done after that? There is no criminal record after that. These are allegations that she's imposing. So I ask that you walk with that lightly.
Okay. All right. We will.
Thank you.
And we likely will be following up with both of you for additional information.
Please.
Thank you both. Thank you both for participating this afternoon. Really appreciate it.
Thank you.
Thanks so much. And thanks to my colleagues, Dan and Martin, as well. Appreciate it.
Thank you.
Bye.
Thank you, everyone.
Goodbye,
Bye.
everybody. Thank you.